Good morning, everyone. Apologies for the delay in beginning, but thank you all so much for being here today. I'm Diksha Gujral, and the India Program Director of iProbono, which is a social justice organization that focuses on child rights. We provide direct legal support to children. We engage in advocacy and legal research. We provide capacity building support to our partner organizations. And as of the last year, we've been focusing increasingly on juvenile justice issues as well as the issues faced by children in conflict with the law. It's such a pleasure to be moderating a session that is too far often ignored. It's a topic that we really don't speak enough about, which is the incarceration of children in adult prisons. As many of you know, the Delhi High Court has been looking into this matter for some time now, but it's still a pervasive issue on the ground. So iProbono began conducting an RTI-based study on this topic last year, which I will let Gitanjali and Ramina and Krishna from our team tell you a little bit more about in due course. But let me start first by introducing to you our incredible panel. So we have the privilege of having with us today Mr. Anurag Kundu. He is the chairperson of the Delhi Commission of Protection of Child Rights, the DCPCR. As the chairperson, he is responsible for monitoring the implementation of the rights of nearly 5.5 million children in Delhi. He's also responsible for commissioning research studies, inquiring into specific complaints and violations of their rights, and advising the government on policy matters. Thank you, Mr. Kundu, for being here today. We have Ms. Anuradha Shukla with us as well. Anuradha ji, for more than 3 years, was the principal magistrate at JJP1. Other than acting as a special court in numerous courts in Delhi, she's also been the secretary of Karkaduma DNSA and is currently the secretary of the Delhi High Court Legal Services Committee. No event on juvenile justice would be complete without Mr. Anant Pastana. Anant, other than being a renowned child rights advocate, was one of the first people to bring iProbono into the field of juvenile justice. So for that, I thank him. Anant is also has many years of experience litigating on issues that impact children, and many of his judgments that he's been involved in have shaped the law as it stands today. He's also a member of the core group of children of the NHRC. I'm also privileged to introduce to you Mr. Avnish Kumar. Avnish is a second chance fellow who works on reintegration of prisoners into society after their release. His journey in the prison system began in 2015 after his arrest in an unexpected event, and he was in Tihar jail for 5 years, during which time he faced many difficulties. Ever since his release, he has been working on the rights of prisoners and the rights of children in conflict with the law. So thank you, Avnish. Finally, we have Gitanjali Prasad, one of iProbono's very valued supporters and advisors. She currently works at the Azim Premji Foundation's Access to Justice vertical, and before this, she was a Constitutional Values Fellow at the School of Democracy. She has worked as advocacy lead at iProbono and at the Center for Equity Studies. So thank you to all of our wonderful panelists for being here today. I'll just start with a couple of brief housekeeping rules. Over the next 2 hours, you will hear from all of our panelists. And then at the end, we will have a question and answer round. So if you could please retain your questions for the end. This will also be a bilingual session. दोनों English और हिंदी में हम आपसे बात करेंगे. I think without any further ado, let me start with taking us to the ground realities. मैं आपको नहीं बताऊंगी कि असलियत में क्या होता है. इस मेरे से बेहतर अवनीश कुमार हमें बता पाएंगे. इनकी एक्सपीरियंस में जो लड़के 18 साल से कम के होते हैं और तिहाड़ जाते हैं, वो किन इश्यूज को फेस करते हैं, कितनी देर तक रहते हैं और निकलते कैसे हैं. सो अवनीश, थैंक यू.
Thank you, Diksha. Good morning, everyone. जैसे कि बताया, मेरा नाम अवनीश है और प्रोजेक्ट सेकंड चांस में मैं फेलो हूँ और मैं भी लीड कर रहा हूँ कुंजी हेल्पलाइन पोस्ट रिलीज असिस्टेंस. तो मेरे साथ भी कुछ ऐसा इंसिडेंट हुआ जिस कारण मैंने अपनी जिंदगी खूबसूरत 5 साल तिहाड़ जेल में दिए. और जब मैं अंदर था तो महीने में 3 से 4 जो जिनकी एज 18 से कम है वो देखने को अक्सर मिल जाते थे. तो कई बार ऐसा होता है कि उन्हें खुद नहीं पता चलता कि हमारी एज कम है और हमें यहाँ क्यों रखा गया है. तो जैसे पूछ लिया उनसे कि मतलब आप इतने छोटे हो, आप यहाँ कैसे? मुझे तो नहीं पता कि मैं कहाँ मतलब जाना चाहिए मुझे, या तो बोलते कि मेरे पास कोई डॉक्यूमेंट नहीं है, कोई प्रूफ ही नहीं था मेरे पास, जैसे आधार कार्ड नहीं बनाया तो पुलिस वालों ने जो मन में आया वो लिख के मुझे यहाँ भेज दिया, या फिर वो उनकी एज जो डॉक्यूमेंट्स में है वो गलती से कहीं बाई मिस्टेक खराब हो गई, मतलब गलती से कुछ और लिख दिया तो इस बेस पे कहीं भेज दिया। तो रीजन उनके अलग अलग होते हैं, पर एक्शन कोई वहां लेने वाला नहीं होता है। अगर कोई सुपरिटेंडेंट या डिप्टी सुपरिटेंडेंट अच्छा है तो उसने एक्शन ले लिया, तो वो प्रोसेस करीब 1 से 1.5 महीने तक जाता है कि उसको उसके आईओ को बुलाया जाएगा, वेरिफिकेशन करवाई जाएगी दोबारा, या फिर कोर्ट से अप्रूवल लिया जाएगा कि इसकी एज कम है, ऐसा कुछ। तो जब तक वो 1 महीने का उसका सफर होता है, उसको एक्चुअली एक तो जेल में ये होता है कि कोई जब कम उम्र का जब कोई बच्चा आता है तो उसके साथ एक अपनी पर्सनल काम करवाना, जैसे कि बड़ा कोई इंसान है उसको दबा रहा है छोटा, और इस तरीके से वो फेस करते हैं। और कई बार तो कुछ ऐसे शिकार हो जाते हैं उनके साथ सेक्सुअल बदतमीजी की जाती है, बहुत कुछ होता है, कुछ पता चल जाता है, किसी किसी के बारे में कुछ बता देते हैं अफसरों को, लेकिन ये बातें फिर दबा दी जाती हैं। तो ऐसे ही एक सन 2016 से बंद था, एक लड़का था, तो करीब उसने 3 साल कुछ महीने का सफर तय करा तिहाड़ जेल का, जो 5 नंबर जेल का। फिर उसके बाद उसको 3 साल कुछ महीने बाद उसको जेजी में ट्रांसफर किया गया। तो ऐसे कई सारी कहानियां हैं हमारे मतलब तिहाड़ जेल की जो हमने देखी हैं, जो बच्चे आते हैं उनके साथ बहुत गलत होता है, और फिर वो मतलब एक तरीके से कि पुलिस अपना काम सही से नहीं कर रही है, या वो कह सकते हैं, या फिर जो उनके माता पिता पेरेंट्स हैं, अब वो तो अपनी पूरी अच्छी तरीके से अपने बच्चे की परवरिश करते हैं, और फिर वो डॉक्यूमेंट्स वगैरह वो सब बनवाते हैं, लेकिन पता नहीं कहाँ से ये इश्यूज आ जाते हैं। और लेकिन वो उनके लिए बहुत ही डिफिकल्ट सिचुएशन होती है उन बच्चों के लिए। एक एज अडल्ट हो या फिर एज उसकी पूरी हो तो उसको इतना इशू नहीं होते हैं, और वो छोटी सी उम्र में वो सब देखते हैं। और वहाँ का जेजीबी से और बिहार का जो सिस्टम है रहने का, खाने का, पीने का, वो बहुत ही अलग है, बहुत डिफिकल्ट है। वहाँ पे लोग ही कुछ अलग तरीके से वहाँ मिलते हैं। तो इस तरीके से मैंने ऑब्जर्व किया और आप सबसे शेयर कर पाया। थैंक यू।
कई लोगों की सवाल होंगे जब वो एंड तक होल्ड करेंगे। थैंक यू कुछ शेयर करने के लिए। अब थोड़ा हमने ग्राउंड लेवल एक्सपीरियंस सुना है, उसके बाद थोड़ा हम डेटा भी देखते हैं इसके बारे में क्या क्या हो रहा है। तो मैं गीतांजलि को हैंड ओवर करूंगी। गीतांजलि, कैन यू टेल अस अ लिटिल बिट अबाउट iProbono study, the inspiration behind it, what the data indicates so far? Thank you.
Thanks so much, Diksha. I think I want to just begin by saying that, motivations to be engaged on this issue, like for everybody present here, they're varied. For us, for me, it was 13 years ago, it was Anand, who sort of mentored me and showed me how to ask questions thoughtfully about the system and engage with it. I never met somebody who was so quiet and gentle and yet worked with such urgency on one issue in a dedicated manner. It was a great inspiration. And similarly, he has been around for Krishna's journey over the last year during the course of the fellowship. So I'd say that's really where it all begins for us. There is an incident that I'd like to share with you that Diksha thought also would be helpful for you all to understand where the roadblocks are. I think Avnish has shared many of them through his experience. This particular case was witnessed during the study that we were doing while at the Center for Equity Studies on outcomes for those charged under petty offences across Uttar Pradesh. It was a study commissioned by the National Human Rights Commission. And it sort of indicated three broad features of what happens to a child that is engaged, in the adult incarceration system. One is that, of course, they're typically children who are excluded and largely invisible to the state until something happens and they come in conflict with the law. These are children who are neglected, typically, both within their immediate ecosystems, but also and very culpably by state institutions. The second is that they obviously once they come in conflict with the system and once they're in the prison, they're at a much higher risk for, as Anish said, physical, sexual abuse and trauma. And it's difficult to identify how this trauma will manifest or is manifesting at the time. But I think the thing that we realized when we were interacting with these children was that they become completely dependent on adults around them. These adults can be adults who they're coming in contact with the police, or the older convicts in the jail, or the officials at the jail, and they play an instrumental role in the outcomes for these children. So I'm going to talk to you about the case of names changed Raghu and Sham, who we met, who had spent 2 months in Ghaziabad district jail in Dasna. They told us that their experience had been that they were returning from a banquet hall where they were working as daily wagers, and they were carrying a bag with many implements, and some of those implements were sharp implements that they required for their work. And the police arrested them, and they were made to sign on a sheet of paper. They were also made to sign on the wrapped up knives, etc. Those knives were not the knives or the implements that had been recovered from the bag. They were doing basic carpentry. They were helping with upholstery at the banquet hall. But they signed on 2 knives. And while their age was being documented, the arresting officer claimed that if you go in through the juvenile system, you will spend much more time in jail than you will if you go through the adult system. You will have to go through a very long process. The JJB takes a very long time. They recalled all of this from memory from their interaction from 2 months ago. And when they entered the jail, they were told that they would be allowed to plea bargain 2 or 3 months into their time in jail. This effectively means that they plead guilty and they're released early. And when the boys were presented in court, the younger boy, they're both tiny. When you look at them, you know they're boys. You can't ever imagine that they would be adults. The younger boy said, I said in court that I'm a child. And the investigating officer said that these are known criminals in the neighborhood, and the magistrate sent them into judicial custody. In jail, they were assured that they would be released if they present themselves before the jail lok adalat. This is an opaque system where a magistrate will come and ask you if you'd like to plead guilty, voluntarily plead guilty. And then you'd be eligible for early release. The deputy jailer in this case had told the boys that you have the right to have a lawyer that the state will provide you. When they met this lawyer, the lawyer said that if you've already given your name for the lok adalat, I'm not taking your case. We met them at this juncture, and they had submitted their names. We told them what pleading guilty would entail. That it would mean that they would have a conviction, that they would have an adult criminal record, that they were only 15 years old, and that it would impact their futures. They were desperate to get out of prison. The older boy was the primary earner in his family. And he was also putting a lot of pressure on the younger one. And we had decided that they would do this. On the side, we enlisted a lawyer. The lawyer that we enlisted was a person who had come to us through a reference. And he said to us, I don't understand why you are determined to have them be released on bail and to have their case transferred to the JJB. These boys have no future. They're not like you and the rest of us. They don't have a future. So why do you care? Why are you bothering? And I think that this is sort of the fundamental, the guiding principle for how everyone interacts with these children once they're in the system. What ended up happening was that they were very upset that we had raised this issue of their age because they knew it would impact their early release. When the magistrate came for the jail lok adalat, we were present, and we did seem to sort of indicate that they were boys, they were young boys. We went against their wishes, and we basically requested that the magistrate look at the boy's age. He said, he shut the file, he put it aside. He didn't pass orders for a bonus classification test. He did not intervene in any way. He just put aside the file and said that they wouldn't be able to plea bargain. The boys were very upset about this, and the lawyer had been unsuccessful in court in securing their release on personal bond. He had been unsuccessful in convincing the magistrate to also order a bone ossification test. When we went to the jail the next week, the boys had pled guilty in the next jail local adalat, which happens weekly in Rasna jail, and they had been released. There is sort of a second part of the story, which is what happened to the boys after this, which we can talk about maybe during the Q&A, because I think it's an important part of the trajectory. But the point is that the first magistrate who was present did not intervene. The second magistrate released the boys with a conviction. And so these, the blame lies in a distributed way, in a very deep way, with multiple stakeholders, multiple participants in the system. And how can you imagine that a child will be able to navigate this, when this is how the adults around them are putting pressure on them to behave a certain way and to make certain choices. So like this, I think, Krishna, when he was working on JJ issues with Anand, he was doing a lot of commentaries on what he saw as flaws in the system. And in a piece he wrote in March, he said, I wonder what the numbers are on children in adult jails. And that's when we decided to file RTIs. We decided to file them in 4 states. And then, of course, Krishna and Yamana decided to file across the country. And so now they have part of the data that we've received that they're going to present. I'm not actually going to get into what the findings are. I would like Krishna and Yamana to do that. Thank you.
Thank you, Gitanjali.
Thank you, Gitanjali. Hi, everyone. Hello, everyone. I am Krishna Aruna Sharma, a lawyer by profession, and I'm the first and the former Justice Lila Singh Fellow. As Gitanjali told during the fellowship, we started working on this research study on incarceration of children in adult jails. And today, I'll be presenting this study along with my friend and colleague Yamuna Rizvi from iProbono. To begin with, as we have established that the juvenile justice system was conceived as a separate system to treat and try children who have been in conflict with law for committing any offense. So the rationale behind this subject was so that these children should be shielded from the harmful effect of adult criminal justice system and should be rehabilitating and reintegrating them into the society as a responsible citizen. So the data we have obtained in this study highlights the fact that despite having a clear mandate under the relevant law, supported by judicial precedents, legal directions, and the check and balances within the system, the children are still being locked up in adult jails across different states. Data shows there is a massive gulf between the stated aim of the act and its on-ground implementation. So now moving forward, we'll look into the objective of the study. So as we can see, first objective is to ascertain the number of children incarcerated in adult jails in India. Second, to determine to what extent Juvenile Justice Board, in short JJBs, are conducting regular inspections of jails to identify children incarcerated in jails. And third, and most important, derive appropriate recommendation for ending the practice of sending children into judicial custody and inform advocacy on the issue. Now moving forward to the next slide, we discussed about our methodology for the study. This study primarily relies on the responses received from RTI request filed under the Right to Information Act. RTI application filed with the Director General of Prison Department of Prison Authorities of 20 states and 2 union territories between April 2022 and January 2023. So third, the 10 states provided substantial responses, that is more than 50% of their jails. And the data we sought in our RTA application was majorly on the 2 aspects. First, the number of juveniles were transferred from all district and central jails of the state to juveniles home of that state from January 2016 to December 2021. Second, the number of visits made by juvenile justice boards in all districts and central jails in the state, and the number of probable juveniles identified during such visits. From January 2016 to December 2020. And apart from that, other secondary sources that we rely for building the study are government reports, new research reports, news reports, and case laws. Now, it is very important to mention that for Delhi, we filed RTIs for 3 different authorities, that is Delhi Prison, DLSA, and NCPCR. This is because of there's a very specific judgment that was passed in 2012. The judgment named court on its own motion was the Department of Women and Child writ petition 8889 of 2012. In this case, detailed direction was passed in Delhi to different authorities. So now moving forward to the next slide, it is the legal context. I think it's very important for us to understand the legal context behind the issue. So if we see the issue of incarceration of children in adult jails has been persistent, complex, and unresolved issue in the juvenile justice system. Looking at the law of juvenile justice system in India from the Apprentice Act 1850, which is a colonial law, to the present law of JJ Act 2015, we'll see that law has a clear-cut mandate that children in conflict law shall not be placed in jails or police lockup in any condition. Besides, over the period, there have been important judgments passed by Supreme Courts and High Court while dealing with this issue. Supreme Court made a very important observation in a landmark judgment of Silabase say that it is an elementary requirement of any civilized society, and it had been so provided in various statutes concerning children that children should not be confined to jail because incarceration in jails has a dehumanizing effect and is harmful to the growth and development of children. Thereafter, Delhi High Court in 2012 observed the judgment we already mentioned above, that lodging of juveniles in prisons clearly amount to violation of their fundamental rights guaranteed under Article 21 of Constitution of India. Contrary to the provision of JJ Act, apart from adverse psychological impact on these children. Now, very recently in 2020, as Diksha was mentioning, a matter before Delhi High Court, which is still ongoing, it came to light that 800 children were detained in jails of Delhi before being moved to juvenile jail. And very recently, the Supreme Court in Vinod Katara case observed lodging children in conflict with law in adult jails amounts to deprivation of their personal liberty on multiple aspects. Once a child is caught in the web of adult criminal justice system, it is difficult for a child to get out of his unscathed. This all shows that the issue of children in adult jail still exists in our system. Now, very importantly, moving forward, we'll come to the data part, which is one of the most important part of the study. That we'll see what data speaks about the issue. The first aspect of the issue is number of children transferred from jail to observation homes. As you can see on the slide, Assam, there's 477, Bihar, 1516, Delhi, for Tihar prison it's 767, for Jharkhand it's 1122, for Haryana 1313, and followed by Uttarakhand, 1490, Kerala, Mizoram, Karnataka, and Rajasthan. So, if we aggregate and see, we'll see that total around 6,000 children have been incarcerated in jail in these 10 states. 6,000. And subsequently transferred to observation home, where they should have been at first place. Now, moving to next slide, the second aspect of the study, which talks about number of visits made by juvenile justice boards in all district and central jails, and number of juveniles identified. As you can see, the data on the screen talks about number of visits made by JGBs in Assam is 10, and number of juveniles identified during those visits is 72. And Bihar, we can see 95 visits were taken, and see the number of juveniles identified, 548. Followed by Delhi, very surprising, no visitor visits and no juvenile identified. Jharkhand 1 visit, 48 juvenile identified. So this is how you can see on the screen. So why this is important is something that we need to understand. So if we look at the JJ Act, the section 8 of the JJ Act, which talks about power, function and responsibility of juvenile justice courts. Section 8, clause M, talks about JJBs conduct regular inspection of jails for adults to check if any child is lodged in such jails and take immediate measures for transfer of such child to observation. This is a check and balances within the system. But the data shows the number of visits made by JJBs in this 10 state in 6 years is only 662, and total number of juveniles identified during this visits is only 959. So this leaves us with a lot of questions, but moving forward, I would like to hand over mic to my colleague Yamina to take us through data of individual states. Thank you.
Thank you, Krishna. Good morning, everyone. My name is Yamina Rizvi, and I'm a program officer at iProbono. I'll be taking you all through the data of 4 states which we felt had unique data in different ways. First, we have data from Delhi. So if you look at the data on the screen, it is from the Prison Department of Delhi, which shows us 2 data points. One, that 767 children were transferred from jails to different childcare institutions across Delhi in the span of 6 years, which is 2016 to 2021. The second point is that during the same period, 0 visits were made by the Juvenile Justice Board. Now this data is coming from 15 prisons, and from those 15, only 6 have actually provided us data regarding the visits, regarding the transfers, while the remaining have not given us that data. Now, the most striking data comes from jail number 5. From there alone, 730 children were transferred in the span of 6 years. Now, although the number itself is extremely large, but the even more surprising thing was that they've not just given us data in terms of the number 730, but they've also given us the detail of all these 730 children, which is in complete violation of the confidentiality clause under Juvenile Justice Act. So what they've given us is the name of the child, their father's name, sections, and the duration for which these children were there in the jail. This helped us in understanding that there were 679 children who were there in jail for a period of less than 3 months. There were 26 children who were there in jail for a period of 3 to 6 months. There were 14 children who were there in jail for a period of 6 to 12 months. There were 3 children who were there in jail for more than 1 year. And there was this one child who was there for a period of more than 2 years. The numbers are alarming and shows violation of the laws is quite substantial. The second set of questions that Krishna mentioned that we filed in Delhi was with respect to DSLSA and NCPCR, asking them about the number of visits made by their panel to the jails to identify children, which was in compliance with the direction of the ordinance passed in Writ Petition 889 of 2011. Now, what we received from that data is very interesting. There's an interesting play of number. How? So, if you look at the data from NCPCR, as per them, for the period of 2016 to 2021, the number is 868. These many children were transferred. If you look at the data from DSLSA for the same period, as per them, 1,314 children were transferred in the same period. Identified. But if we look at the data from the jails, as that's on the screen, the number which has been transferred, it says 767 regarding the visits made by their panel. So they shared with us the data from the NCPCR panel. Now, if we look at the data from NCPCR panel and DSLSA panel, we find that as per DSLSA, NCPCR has made 54 visits in the span of 6 years, that same period, 2016 to 2021. But if we look at the data of NCPCR itself regarding their visits in the jails, for them it is 34. Now again, we do not know which is the correct number, but there's a huge margin there as well. Now let's move on to the state of Bihar. If you can take me to the next slide. Thank you. Now if you see data over here, we see that 1,516 children were transferred from jails to different CCIs in the span of 6 years, and
95 visits were made by the Juvenile Justice Board to the jails to identify children. Now, this data is coming from 3 central jails out of 8 and 12 district jails out of 33 in Bihar. What was interesting while we were studying the data from Bihar was that there is a year-wise increase in the number of children who are getting transferred from jails to different CCIs. Now, there can be 2 possible explanations for it. One can be that more and more number of children are coming into the system and are getting incarcerated every year, which is a problematic issue. The second possible interpretation can be that the authorities have become more aware, and that's why they're sending more and more children out of the jail. Again, we do not know for sure that which of the 2 interpretations can be applied here. The third major observation in this particular data comes from 2 particular jails. One is Araria and second is Bhagalpur. So as we mentioned about our question, so Bhagalpur, while answering our first question regarding the number of children identified, they informed us that for the duration of 2019 to 2021, only 24 children were transferred. When they were answering the second question regarding the number of visits made by the JJP and the number of children identified during that visit, they answered that 94 children were identified in the same duration, which is 2019 to 2021. So over here, we have a gap of 60 children. We do not know for sure that where these 60 children are. Are they still in the jail? Were they transferred at some point of time? Or was it that they were transferred to some other states and that's why jail have not relied upon that data? We do not know. Similar is the situation in Araria as well, where the number of children identified in the period of 2018 to 2021 stands at 101. But the number of children identified by the JGBs during that same period stands at 159. So over here, the status of 58 children is unknown. Now let's move to the next state, which is Haryana. In Haryana, 1,313 children transferred from jails to observation home in the span of 6 years, and a total of 62 visits were made by the Juvenile Justice Board during the same period of 2016 to 2021. Over here, we've received data from all the central jails and 15 out of 17 district jails, while the remaining jails have not given us data. Over here, Karnal was of particular interest because in Karnal alone, 309 children were transferred in the span of 6 years and 28 visits were made by the JJPs. Let's move to the next state. The last state in our presentation today is Assam. And if you look at the data from Assam, it says that 477 children were transferred from the jail to different CCIs and only 9 visits were made by the Juvenile Justice Board. We've received data from 4 out of 6 central jails and 16 out of 22 district jails. Although the number itself might not come across as very striking if we compare it with the other 3 states, but what was interesting here in Assam was the fact that they gave us some additional information. They just did not stop at giving us information about the central and the district jail, but they also gave us information about the special jails and open jails. And interestingly, we got to know that even in those jails as well, the children are being incarcerated. So the issue of incarceration of children is just not limited to the central jails or district jails. It goes beyond that as well. In fact, there's a special jail in Nagaon from where 29 children were transferred in the span of 26 years. Another highlight from Assam was the district of Udalguri and Deepahu, from where although JJBs were not making any visits to the jails to identify children, but what was happening there was that under-trial review committee and chief judicial magistrates were making monthly visits to the jails to identify the children, which is a good practice and maybe JJBs in future can learn from that. All these observations help us understand 3 major ground realities. One, that large number of children are still being incarcerated despite the law in place. Second, the number of visits by the Juvenile Justice Board, which is prescribed by the law, is either not happening at all or the number is very low. Third, these visits are very discretionary. There is no minimum mandatory number of visits that are supposed to happen. Maybe that is one of the reasons that why the visits are not taking place and children are not getting identified. I leave you here with these numbers, and now I would like to invite Krishna once again to deal with the data challenges. Thank you.
Thank you, Yamina. Now, I would like to share the data challenges in you. So, as we know, the data has been the utmost importance in the study, but we also need to understand that what are the challenges that we came across while collecting this data. I personally feel that while doing the study, is that it's not only helped me to understand the JJ system, but also the challenge and constraint in the RTI, effective RTI administration. So, for example, when we filed for RTI for UP and Chhattisgarh, that's Uttar Pradesh and Chhattisgarh, my application got rejected and no information was provided because on the ground that information which I was seeking was held by different public authorities. So, under UP RTI rules, which allows not public authority not to transfer, and in that case, I have to file separate RTIs to different district and central jails. For example, if UP have 5 central jails and 61 district jails, I have to file 67 or 66 RTIs to secure the same data. So, and for Chhattisgarh, they have the same provision. So, in that case, I had to file 17 RTIs to secure the data. This completely goes against the intent of the RTI Act. This actually has been becomes a very difficult task for the administration to find out the address of concerned jails and keep filing RTI. And then for Rajasthan and Punjab, the RTI application got rejected under Section 7, Clause 9, which says the information shall ordinarily be provided in the form in which it's short unless it would disappropriately divert the resources of the public authority would be detrimental to the safety and preservation of. This were put in the appeals and we got responses. But coming to Orissa, they didn't provide us information because the applicant did forgot to annex as not forgot, I'll say that the rules were not clear, so we didn't annex our ID proof, and I didn't file the RTI according to the format of RTI given the RTI rules. But if you look at the RTI Act, first the Section 8 and Section 9, which talks about the ground for rejection, clearly mentioned that this can't be the ground for rejecting the application. So this is very important to understand that how RTI system is working, and this all shows that bottlenecks in the RTI process. Now moving forward, apart from this data challenge, there's another challenge that we came across of lack of record keeping. Many jails in Delhi highlighted the issue that non-maintaining of record or data not available. This actually goes against the idea of rule of law and accountability of authorities. So this were the challenges that we came across while securing the data for the study. Now moving forward, the next step which will be doing for building our study is filing more RTIs to cover more states. Till now we have covered 22 states, so we'll be filing more RTIs. We'll be filing RTIs in some states to check the JGP visits that took place for 2 jails for inspection. We'll ask for the minutes, and we're also planning to do advocacy with the stakeholders. Now, at last, I would like to mention that a major motivation for us to discuss this study today is to invite our panelists and in audience member, many of whom have rich experience working in the juvenile justice system, to share their thoughts on recommendation to address what we clearly see is the failure of the system, to protect the right of children in conflict with law. And not to forget, but I would like to thank JLSF, Justice Leadership Fellowship team, iProbono, and Anandma Asthana to guide me in working on this project, and it's been a very enjoyable journey. Thank you so much. Now with this, I would like to hand over Diksha to take the session forward. Thank you, everyone.
Thank you, Gitanjali, for the context, and Krishna and Yamina for that elucidation of the document, the data that we have so far. As I mentioned, this is an ongoing study, and hopefully, once it's complete, we'll be able to publish it and share more comprehensive takeaways from the work. So, looking forward to that stage of our journey. But next, in order to get into a little bit more about the ground realities, a little more complexity and nuance, I'll turn to Anand. So, Anand, if you could perhaps walk us through, how the issue first came into the public vision, the factors that you feel contribute to it. Give us a bit of a historical perspective as well as some of the important judgments. That will be very helpful. Thank you.
Thank you, everybody present here. I'm thanking particularly because this issue is one of the most neglected issues as far as the juvenile justice administration system is concerned. So that's why to see so many of you concerned coming together to attend this session. We started at 9:30, which is quite unusual. I was late, I'm sorry. But I wanted to begin with a thank and also to iProbono for taking this issue freshly. Those who have been working on this issue feel tired because it's an ancient issue. It was taken up as long as even before the Indian struggle for freedom started. When was that? 1857. The Indian journey for freedom started. In 1856, the journey for liberating minors from prisons started. Not by an Indian, but by a British superintendent of jail, Charles Hathaway. He was the governor of Punjab prisons. And when I was researching this topic in my early days, I landed upon this scanned letter which Charles Hathaway wrote to, probably to the office of Queen Victoria at that time, I'm not sure. And then after that letter, I couldn't identify what happened, but then the next reference comes in the formation of the first Indian Jail Committee. That was primarily aimed on prison reforms in 1920. That's also a very interesting document because it also talks about incarceration of children in jail. Charles Hathaway wrote that he doesn't care about the region, but he feels unhappy about the fact that there are so many young people in the prison. And he wrote in the letter that as a public policy is not good to have so many young people incarcerated in jail. He was not looking at law. He was simply looking at the impact of incarcerating so many young people in prisons. What kind of society will emerge if any society locks up so many young people? That was his primary concern. The Indian Jail Committee report, though primarily engaged with the process of how prisons can be humanized, how prisons can be reformed, they engaged with the issue of children in jail. So for anybody who wants to seriously engage with this, it's very important to go through that particular chapter, Child Offender, 1999-20 Indian Jail Committee report. That report helps us understanding the dynamics and also settles lots of debate which we have. Why should a rapist not be in jail? Does it matter if he is 16? Why a brutal offender should not be in jail? Does it matter how old he is? A drug peddler, why he should not be in jail? Does it matter what is the age? These are very critical issues, no? And despite there being a very clear law from, I think, 1919, this Indian Jail Committee report which I am referring is the foundational document for juvenile justice law in India. And please take note that the concern which we are discussing today in this conference hall is the concern this 1919 report tried to address. So, in a way, the root for juvenile justice law lies in this very issue. When this event was organized, I was trying to think fresh. Then another gentleman is here. How this issue came up, I mean, I'm sure many people have worked on it before I took note of it. Gopinath Ghosh judgment, Supreme Court has been passing orders since I think 1983. Sheila Bansal, Sunil Batra. There's hardly a judgment of Supreme Court where issue of children being jailed is not mentioned. The remedy couldn't come. That's a different part. The remedy couldn't come because Gopinath Ghosh judgment gave a very interesting observation. It got lost. It was revived in Delhi after 2011-12. Gopinath Ghosh judgment, Supreme Court said that why is it that these claims are not settled at the very threshold? Why is it that somebody has to come up to the Supreme Court and then we have to adjudicate and decide whether this person is a minor and how many years has lost? Why should it happen in the first place? The Supreme Court said it's actually the duty of the magistrate, before whom an accused is produced, to satisfy that the person produced before me is not a minor. The claim of juvenility is very critical component. Can courts so moto take an issue? So 1953, Supreme Court said that. In Delhi High Court in 2012, Gopinath Ghosh judgment was taken note of. The magistrates were imparted training by the judicial academies. But apart from that Gopinath Ghosh, nothing concrete came for a very long time in terms of what can be done to stop it as a problem. I remember Assam, you mentioned some data about Assam. I remember there was a group of lawyers, I forget the name, I think Legal Assistance Forum, I'm not sure, Legal Assistance Forum, headed by a senior advocate. They did RTIs in Assam. And then they found out a large number of minors being in the jail. I think it's 2007-8. Then I also saw there is an organization called Commonwealth Human Rights Initiative, CHRI. They have also been tracking some cases of Bihar where minors have been. So you see the civil society engagement with this issue, but not a very consistent one. Courts also not very coherently looking at the problem. In 2010, I witnessed the process, and that process has been witnessed by me and by another man because he was the principal magistrate in the Juvenile Justice Board at that time. A minor who was just released again came. I informed the board. I was legal aid lawyer. I informed the board. And I said, you have released this boy a few days ago. Now his mother is calling me and saying that he has again been picked up and locked up in the Bihar jail. So orders were passed. A detailed order was written. I have shared that order with Diksha few days ago. It's also published by her Center for Child Rights in that booklet where 14 JLB orders have been published. That order took note of the nature. Apparently, the police official in that case had no malafide. The guy was not angry. He was not throwing anybody in jail. It's just that the procedural detail was so daunting that it took 4-5 days for even the system to bring that child from jail to Juvenile Justice Board. That order, along with the RTI, we showed it to Delhi High Court. And that order, today Rohan Alva is not here. There is another lawyer who was interning at that time with me. And Juvenile Board had appointed him amicus. We have heard amicus in High Court and Supreme Court. With JJP, I think Rohan remains the only amicus. After that also no amicus. He filed a report and he came out with a very original remedy. He said when the detention was taken note of in Dikabasu, the response, the remedy was arrest memo. Arrest memo, Criminal Procedure Code is prescribed for arrest memo. It comes from Supreme Court guideline. So it's must be a documentation of this. Police officials do not have any law. Please take note of this. Police officials do not have a law which guides them how to investigate age. There is a law for courts to decide age. Gujarat is the only state which 2019 issued some very cryptic rules on age investigation. So it's difficult for police officials also to investigate. Anyway, I don't want to go into details much. But then, because of what happened in Delhi, and how it happened, I think that's important. There were escapes happening. Lots of escapes were happening in the homes. Government decided to frame rules for maintenance of discipline by minors. There was a committee constituted. I think the committee was headed by you, the drafting committee for disciplinary rules. And Bhartiya was member, P.P. Dhal, joint director from department, very active officer, he was member. So when we started meeting and discussing together, the course of the rule making changed. From discipline, we came back on juvenile justice because we found that these children who are escaping and creating a jail-like environment in the institution are the ones who have actually spent time in jail. Right? So the atmosphere in the institutions is already vitiated because of the children who first go to jail, spend few months there. It's a very tough life. Anybody has been to jail? Yet.
I like how you look at me for that.
So I was thrown up in a police lockup the day I reached Delhi for the first time in 2008. So I had this experience of being locked up in a police station and then saying that I'm a lawyer, so locking up in a toilet. It's a few hours. And there, the committee discussed with this aspect that before we put rules on discipline, should we not take note of this problem? Why children are going to jail? So then the committee wrote a letter to the Commissioner of Police. Commissioner of Police very sensitively responded and issued a general order to all the investigating officers. Please carry out age investigation, prompt age investigation. You know the fate? Order remains order on the paper. How does it translate into the practice of a police official? It didn't bring much result. Confirmation came from the highest office in the Delhi police that the problem is acknowledged. And the commissioner said, I'm issuing orders to my investigating officer, but that didn't help the investigating officers. So, what concerns me the most is, and with that I will conclude, that the argument against juvenile justice law is that this gives immunity to minors who commit crime. Your system doesn't work, right? Juvenile justice system doesn't work. Reformation is very low. Justice Anu Bambani in an event was saying that while we deal with problems, we also look at the source from where the problem is coming. Why juvenile justice system is not capable of responding to this challenge. You read the statement of object and reason in the Juvenile Justice Act of 2015. That is fifth point written that the law as it is stands in 2000 has been found inadequate to deal with juvenile crime. So inadequacy is why there is inadequacy? Because the challenge which should not exist before the system has been created by the system itself. A child so vitiated that you find yourself incapable of reforming is so aggressive, so defensive, so manipulative. How do you reform? If this boy would not have been into jail, for 6 months, he would have been a very easy person to reform. Now he has learned all the difficult survival tricks, making him very defensive. So communication becomes difficult. His faith in the system is almost gone. His faith in goodness of people has disappeared. That people are good and can help you out, that is gone the moment you are in jail. Because in jail the survival operates on a very different manner. It's a bargain. So incarceration of minors has to stop if juvenile justice system has to work. We can't have a situation where children are routinely going into jail and then we are also complaining about the juvenile justice system not working. If juvenile justice system is not working, one of the main reasons is that we are sending children to minors. Right? All of us are trying to understand this. Avnish is here with us. Thank you, Avnish, for joining. We have to hear the stories because as a lawyer, I am told that system can only respond if you put up a moral face to a problem. As long as people sitting in authority do not see the moral side of the problem, you can't get them to attend your problem, right? In this debate, somehow we have to more carefully listen to the experiences which Avnish brings on board. There are millions who will never get the opportunity to tell their story. But if we listen their stories carefully, I think we will be able to find that moral angle to the problem, and then that moral angle can be a very good starter for a conversation, engagement with those who hold power and have responsibility to put an end to this problem. That includes legal aid lawyers, that includes magistrates, that includes police officials, that includes statutory commissions, that includes citizens, that include NGOs, that includes social workers, whatever way we engage with children. Right? So I think I will stop here, Diksha. Thank you.
Thank you, Anand. And I think the main takeaway that I have from what you're saying also is it's not just, it is an issue that involves every child within the system, but it's also an issue that involves all of society there. Because if we're talking about an issue where each child who spends time in jail, not only is their own rehabilitation impacted, but all the children they will be with when they're in an observation home in the future, the society that they will re-enter will be impacted by the fact that these are children who have been irrevocably transformed for the worse through this experience very often. There are always wonderful exceptions to the rule. People who come and despite all the adversity they face, they are able to contribute so wonderfully to society, and I'm so grateful that we have Avnish here as a representation of that. But we do have to recognize that as a society, it impacts us all. It's not something that, someone who's looking at this as a moral compass needs to focus on. It's something that impacts us all. So that is a really important takeaway. So thank you for that, Anand. We've been talking a lot about the system and the way that the system is not able to take on the issue before the system is failing these children. But there are the complexities that the system itself faces. And we're very lucky that we have Anuradha ma'am here today, who's going to be able to shed some light on that. Ma'am, I read an order that Anantha mentioned, where a boy who had previously been arrested and had previously spent time in the jail and his age verification was done, was picked up again and was once again in the system. And you passed a very detailed order regarding this issue come to light repeatedly over and over again. You've also been able to, speak firsthand about what are the limitations on the JJDs to conduct jail visits. You also are now the Secretary of the Delhi High Court Legal Services Committee, and so your insights on the responsibilities and limitations on lawyers would also be very helpful to us. So now I hand over the stage to you. Thank you.
Thank you, Diksha. I think I'm audible without this. No? Hello.
Is it okay?
before I start to speak of what I have to say, I'll take 1 minute on the data that you have presented. One, I am not sure how you are saying that the visits in Kerala and Rajasthan, I think were 0, yet the persons identified were 5 and 181. So there were no visits by JJB. Because for Delhi you are saying no visits, no identification. But for Kerala and Rajasthan you're saying 0 visits and some identification. So we need some clarification whenever you can later and I am saying it because I might forget. 2 is when you said that 730 from jail number 5 only. I'm not saying it from the side of authority, but a little bit of research would have shown you that yes, this is how it should have been. In fact, to my understanding, all 767 should have been from jail number 5 only. What surprises me is not that 730 were from jail number 5, but that 37 were from somewhere else. Because it is jail number 5 which keeps the youngsters from the age of 18 to 21. So all these persons should have been from jail number 5. So you should be worried about these 57. Where did they come from? And that's it. So Anant was giving a little bit of history of how it all started, and then like from English law and mentioning a little bit about the Sheila Bharse case and then Gopinath, and he suddenly came to 2011. I'll tell you a little bit of what happened from 2000 till 2011. We had an act in which the age of majority, the age of criminal responsibility was 16 years for the boys till 2000, right? So the children up till the age of 16 years were being kept in jail. The boys, not the children, the girls. For the girls, the age was 18 years. For the boys, it was 16. So they were legally being kept in jail. In 2000, the new act came, and the age of minority or age of criminal responsibility was increased from 16 to 18. Now, the children up till the age of 18 years, in whatever manner they were involved in any kind of criminal offence, were to be considered as children. Delhi got its first juvenile justice board in 2003. In between, the older children court kept on working as the juvenile justice board by the orders of High Court, because the JJB was not set up by WCG. In 2003, the WCG set up the board, which was initially set up for 3 years only, right? So this board was again expiring on 4th April 2006, I think. So it was with the intervention of High Court and our magistrate who was posted there, Mrs. Ella Rawat. They all have worked very hard, and therefore it is important for you to know, yes, we have not been able to do a lot that is required, but we have tried to work to the extent we could. So it was the effort of Mrs. Ella Rawat and Madam Justice Aruna Suresh, and by then we had Juvenile Justice Committee. They all acted and the proper board was created, the infrastructure was put in place. During this period, the children between the age of 16 and 18 were regularly coming from the jail to the observation home, and their cases of those children who were on bail were also being transferred from the adult courts to the trial courts. There wasn't anything absolutely wrong with it at that time, because it was the creation of a law. The children before that, between the age of 16 to 18, were legally in the jails, and they were legally being transferred to the observation homes, right? So between that period from 2003 and I would say till 2008-9, it didn't shock us as magistrates of JJB if a child was coming from the jail, because it was a gradual process. They were all coming, and we never saw any violation of law, because in some cases it might have been, but it felt that it was happening because the law has changed. So nobody focused. Why it has been an ignored aspect for a long time is I'm trying to kind of trying to explain. I don't know whether it's a valid excuse and it's not an excuse. It's fact that for that age group, we wouldn't get shocked or surprised if suddenly a child of say 17 and a half or almost 18 was brought from the jail to observation home, because we were seeing many of them coming from there. When I joined in 2008, and then again I'll point out, when a new law comes, it takes you people, the activists, like you are quick to observe the changes. We take our own time. Why? And I'm not saying the magistrates of JJB, because they again are experts, but the judges who are sitting in the trial courts, a lot of them are dealing, and most of them are dealing in different fields. Somebody is looking after the NDPS cases, somebody is doing the regular, criminal cases, somebody is sitting in a civil jurisdiction, and they are doing whatever they are doing sitting there. So we do not come to know the everything about the law. The moment a law is framed, it takes a lot of time for the law to reach us, and mostly it happens when we get a case related to that statute, or some discussion happens, like it is happening in this forum, or we are taken to the academy. Then we come to know. Nowadays it's easier because everything is available on your smartphones. Back then it wasn't, right? We didn't have, and I'm talking about 2006, 7, 8. There was no such medium. We would not know the law. The law was the law was what we got from All India Reporter and everything. And if a lawyer brought it to us, or a Supreme Court directed a judgment to be circulated. Now I think I'm diverging a lot. I'll come back. So it was till 8, 9. We were treating it as a routine thing. The children come from jail to observation home, and there's nothing wrong with it. Around 2009, as Anand also pointed out, we started having there was a lot of turbulence in the observation homes. It had started for a long time now, but it was suddenly a lot. We don't know what the reasons were, but during 2009 and 10, we were facing a lot of violent incidents happening in the observation homes. And as he mentioned, the committee was set up. We started looking into why it is happening, why suddenly we are facing such issues. So, and in the process, we realized that these are the children, but we didn't know what to do and all that was happening. And suddenly, then this child was brought before us, who was in the jail, and he was in the observation home in 2010, and suddenly he was released, and then the information comes to the board that he's again in custody, and I didn't know. And with this, I will take you to the question of Diksha also, that why the boards should not be, or whether they should be going to the boards to find out whether the children are, whether the persons there are children or not. We realized that there was something wrong. We wrote, and what we realized also, that it's not one person's fault in every case. In some case, it could be a IO's fault. In some case, it could be, because in this case, we felt that there was some lapse on the part of the magistrate also, some lapse on the part of IO also. Now, this child says that he was telling that he was a child and he should be taken to the board. That part was neglected. The magistrate did not ask the child, who was apparently looking to be a younger boy. As Gitanjali also mentioned when she was saying that those boys were actually looking boys. So this boy was actually, he looked like a boy. So definitely it was ignored by the court. And then, of course, at the jail level, nobody took note of it. So we realized how we can do it, and I will give you a few steps that we found. One is that the IO, the moment he arrests a person who says his age to be 18 to 21 years, he should necessarily ask for the age proof of that child. This is what we wrote. You just cannot say that he said 19, so I believe 19. And because he is 19, no, age inquiry is required. We are not expected to ask for documents from, 25-year-old or 50-year-old of the age. We are not expected to. So we don't do it. So we said no. No, not only in the cases where the child is saying he's below 18, in all the cases where the age of the child is between 18 to 21, you have to mandatorily ask for the proof of age of that child. And to add, we also said that you also ask the child if he has been into the system of childcare in JJB or in CWC at any point of time. That will help you in having access to his the record of his age, right? Then we requested our magistrates, whenever a case of this kind comes before you, where the age of the person before you is written as 18 to 21, you conduct a preliminary inquiry. Don't just close your eyes. So if 18 to 21 comes before you, just ask the person, and that started also. Like in around 2011-12, I think, there were a lot of cases in which inquiries were conducted, and we got a lot of cases from the adult courts also. A lot of children were transferred also. So we tried to check it at two levels, right? A little awareness was created, and we got good response also. But the data that you are showing us, in fact, shows I was out of system 2012, and since, as I said, we cannot remain like Anand can afford to remain a child right lawyer all his life. I cannot remain person interested in child rights all my life. I was sent to an NDPS and a regular sessions court, so where I had nothing to do with child rights. So I don't know what happened, but we tried to check by making these, and then yes, we also said that. The record of age of children, whoever come into the system, should be maintained, and it should be shared. That part, I think, never happened. That in the police stations, the GWOs should maintain the record of age of children, and that data, without the name of children, something you will have to find out, should be circulated amongst the police stations, should be shared with all the GWOs, and whenever a child is apprehended, not in the same police station, anywhere across the city, the GWOs know that the person has been a child, and has appeared before a juvenile justice system. So that's how we worked. And now coming to that question on why the JJB, to my understanding, is not the right authority to and the board members and the principal magistrate are not the right persons to go to the jail to identify the persons as children, right? And one I would say is why, because the children in the jail are already under the jurisdiction of some other court, and 99.9% of the times, this person under whose authority that person has been kept in jail would be a judge senior to the juveniles. Now, seniority doesn't matter, but the hierarchy does. In judicial system works in a hierarchy, and a magistrate cannot, by any I should say, by any law or otherwise, propriety, you may call it anything, under law also, direct a sessions court to transfer a matter to the JJB or to transfer the child. So, like how it will be, yes, they can visit and they can actually prepare a list of the person who they feel are juveniles, and then they will have to share it with the district and sessions court judge concerned. And it is the district and sessions judge who will have to take the required steps. But that, in my opinion, has already been done by the SLSA. The SLSA is doing the same thing. They are identifying the children, and then they are sharing that list with the district judge, and then sharing it with the judges, and the children are being transferred. So that is already happening. Why we want the JJBs to do this, I do not know. Though it is now in law and it is their duty to do it, but how is it going to help? I have my reservations, and I don't think it would be appropriate. Also, like if I go to the jail and I don't know if you will be in a position to understand there is a difference between investigation and an inquiry being conducted and a judgment being pronounced. So the law says when I discover a fact, then I would not be the right person to decide on it. So वो बहुत ज़्यादा juristic हो जाएगा. I will not go into it. There will be problems. So I'll hand it.
Thank you for very candidly sharing some of the limitations that the system faces, and I don't think we can really identify solutions to a problem without recognizing the constraints on the system. So I appreciate that you gave very candid feedback on some of these issues. It's very enlightening for all of us. I will now turn to Mr. Kulu. So when we look at the AAA judgment, there were obligations placed on very, very different stakeholders, on police, DGP, magistrates, the DSNSA, the courts. The DCPCR, of course, was not on that list, but I know that you have been working on this issue, and I know that you have been responsible for the oversight or working with very many of these other stakeholders. So if you could share some light on some of the ground realities that you have faced on how the system is responding to the current policy framework, and anything else that you feel is a possible solution to a problem that we have not yet found a sustainable solution.
At the cause of children in keeping them away from a horrendous system. So to that effect, thank you very much, and I hope you continue even after your fellowship, if that's already over, but continue to take up the cause through RTIs and through other different means at your disposal. Few comments, because I have been on the other side of the table sometimes, having my office respond to RTIs and sometimes far too many. And those are caveats of sometimes, and I used to be in a similar situation as you, let's say about 7-8 years ago, when I filed a lot of RTIs when I was doing a research study on RT, and I used to get horrified about, oh, this system is saying 17 children, and this system is saying of the same period, same context, same setting, 19 children. Where did the 2 children go missing? And I used to, and for all the right reasons, and one should. And as I started to understand government more, I realized the children are not missing, it's just poor data management. So while the issue remains alarming, the issue remains worrying, because in 2 children not properly documented is a 2 children we have missed out the rehabilitation of. But the rage and the extent of the alarm is not the same as both 2 children are missing. So that's the first caveat when it comes to how to read government data, which sometimes we obfuscate, sometimes on purpose, sometimes because we are very incompetent, and even we don't know that we are obfuscating. Other times, it's just extremely poor data management. The second, this under the table view that I've developed is the RTs are responded by public information officer, who's typically not very senior official, who's typically a middle ranking and sometimes not even middle ranking official. And no one official can have expertise on so many issues that sometimes the department, the commission, the different authorities may have to deal with. So sometimes it becomes a function of the PIO's ability to understand the question. And it becomes less of a response of what you're asking, it becomes more of a response of what I know and what I can give you. It's almost like an engineering exam. आप कुछ भी पूछते रहिए, मैं वो लिखूंगा जो मुझे आता है. And then we take the data very seriously about, oh, this is what they meant, and this apostrophe is missing, which means this, and the other person didn't even bother to look into the apostrophe actually while writing. So that's the second pinch of salt that we have to take while we read government data. So sometimes multiple RTIs and follow-up may rather help in clarification. So that's my advice, because I've been on that side and on this side, being obfuscated to and obfuscating to both sides. So it's a little bit on that. So those are the 2 caveats that I wanted to strike on the study, and your study is a great service in the collective cause, and I'm very grateful, like Anand said, for initiating a discourse like this. But back to your question, Diksha, let me first, at the cost of perhaps sounding repetitive, to the point that Radha ma'am made, and Anand made, Patanjali made, Avnish made, and Krishna and Yamina both made earlier. Let me trace the process flow. One person is apprehended by investigating officer. The eyes of the investigating officer, and I'm going to the Juvenile Justice Board and Child Welfare Committee, their first method of age determination or determining whether a person is child or not is by appearance. So चाइल्ड वेलफेयर कमेटी के पद पे या जुवेनाइल जस्टिस पद के बोर्ड के पद पर या इन्वेस्टिगेटिंग ऑफिसर के पद पे या तीनों में से कोई नहीं, आंखों में अगर सितारे किसी के नहीं है तो अगर वो अपीयरेंस एग्जामिन कर सकते हैं तो वो भी कर सकते हैं, करेक्ट? ऐसा नहीं है कि जिस दिन गजट नोटिफिकेशन आता है तो गजट नोटिफिकेशन आपके आंखों में कुछ अलग सितारे लगाता है. So the ability to determine by appearance is essentially the same. One holds an official power to write the judicial order, one does not. But the ability and intention is not dependent on the gazette notification. So investigating officer then is as capable or as incapable of determining or at least suspecting someone's age as below 18 or perhaps below 18 as a juvenile justice board member or a child welfare committee or somebody else is. So the first breakdown happened in the investigating officers. So perhaps suspicion should have risen. क्योंकि 15 से नीचे क्लैरिटी होती है पेरेंट्स पे, 20-22 ऊपर भी क्लैरिटी होती है कि अडल्ट है. This 5-6 साल का जो विंडो है ना, यहाँ पर समस्या है, which is you're not fully sure whether 18 in this side or 18 in this side. But in matters such as this, it's good to err on the conservative side. So the first breakdown happens in investigating officers, and once we start mapping the milestones of the breakdown is when the solution starts to perhaps emerge. So first, the second breakdown happens at the milestone of the person being apprehended. I'm not faulting the person being apprehended. I'm only saying that juncture. It is our collective failure to inform our citizenry that such a legal provision remedy is available in the law. Why shouldn't we teach that in school right from the time the students are in class 8, class 9, class 10, class 11 and class 12? That's the time period to make them legally aware. So the fault does not lie with the person being apprehended of not being informed, but the fault lies in us not being able to inform that person. But juncture is that. So that's the second breakdown. And that's when the solution starts to emerge as well. So that happens. The next immediate step is production before the magistrate. Now again, any regular magistrate does not have any less or more eyes than the eyes of the Juvenile Justice Board. So when that person who may have been suspected to be a juvenile is presented before the regular magistrate should be as duty bound or is as duty bound already actually under the judgment to say, oh, this might perhaps be a juvenile. And that sentence alone opens up windows. And nobody needs to ascertain at that stage. But that sentence alone is a great starting point. But how does a child land up in jail? No person lands up in jail without a judicial order. That means there's a magistrate behind. That's a breakdown number 3. The 888-9 judgment provides one more step before the magistrate and after the apprehension, which is production before the district secretary of the Delhi State Legal Services Authority of all apprehension where the age is under 21. The age memo says 19 or perhaps 20 or perhaps 21. That production we found out in the course of a specific court matter was not happening. So both sides are blissfully unaware. The side that is supposed to be producing, the police, and the side that is supposed to be produced to the Secretary District Services Authority. And that is a step. So once I am the IO and I know मुझे एक judicial officer के सामने लेके जाना है इसको जो मेरा age memo examine करेंगे. I'm going to psychology. An IU is not a commissioner rank officer. An IU is a very junior official. And a very junior official has to present an age memo to a sitting judicial officer. The moment I realized this, I will do a slightly better job at that. It's like अगर कोई कोर्ट मैटर चल रहा है ना और मुझे लगा कि भैया जज मेरी ओरिजिनल फाइल कॉल फॉर ना कर ले तो आदमी एकदम से फाइल बेटर मेंटेन करने स्टार्ट कर देता है प्रॉपर डॉक्यूमेंटेशन व्हाटएवर जज साहब आस्क्स फॉर इट सो इफ अ कमिश्नर रैंक ऑफिसर is very cognizant of that psychological impact of a judge asking for a file, that has to play to the advantage of the juvenile. That doesn't happen. So that's a step 4. The magistrate then sends this child, suspected juvenile, not necessarily a child, to the hub. Thereafter, the Triple Act 989 provides one more remedy. And it says within 24 hours, if the jail authorities suspect this person to be a juvenile, so the judgment is again acknowledging कि Child Welfare Committee और Juvenile Justice Board के आंखों में सितारे नहीं हैं, वही सितारे अगर है तो jail authority के आंखों में भी हैं, तो वो भी कह सकते हैं perhaps juvenile है. The authority that the jail staff does not have is to not abide by a judicial order of the magistrate of इसको अपनी जेल में रखिए. That authority does not belong to. But the judgment allows and encourages and rather obliges the jail staff to at least raise a flag. Then, my lord, this person may perhaps be a juvenile. So that layer of shield also needs to break if any incarceration exceeds 24 hours. Thereafter, if the flag is raised, the ball is again in the regular magistrate's court. So that shield again has to break for the incarceration to continue. Thereafter, the same judgment provides for the jail inspection by the NCPCR, and that monthly provides for a clear frequency, monthly inspection. Now, that is the other cause of the maximum incarceration should continue before a flag is raised after all this shield is being broken already and breached. Is the 30 days time period when the NCPCR team should visit and should raise a flag of someone possibly being a juvenile. And the other remedy that the statute provides, and while I agree with Anuradha ma'am 99% of what she said and remarkably said so, this is the point of deviation. And the point of deviation is the statute does not expect a junior ranking principal magistrate official to pass directions to a senior court of sessions. It only says inspect the jail, and the expectation is raise a flag.
That we agree, that I said that much they can do, which ASLSA is already doing.
Correct. And raise a flag. And again the ball goes to the regular magistrate's court for looking into the flag raised by another judicial body called Juvenile Justice Board. That also has to be breached for the incarceration to continue. And in cases where the incarceration was found to be wrongful, such as Amnisha's case, the judgment further provides for 2 more remedies, which is when the child is transferred to the Juvenile Justice Board, the Juvenile Justice Board is mandated to conduct a preliminary inquiry as to what circumstances led for this child, this juvenile, to be incarcerated in the adult jail. That preliminary inquiry is that happening. And if the preliminary inquiry establishes a police official's fault, then the disciplinary proceedings must be initiated on the directions of the board. All of these layers have to be broken for an Amnish to spend time there. Imagine if one of them worked, then the incarceration of these 700 something that you talked of wouldn't happen. Even one of them to be worked at any stage. So all of them have to be broken. And that's what the solution is. Make any one or two of them work. And then make any one or two of them work would result in the numbers starting to drop. And the time periods of incarceration starting to shrink. And that's what the solution lies. So just make any one or two layers work. The earlier layer works, the better it is. The earliest layer is IU, the person being apprehended being informed of his or her legal rights, the production before the DSLSA, the production before the magistrate. These are the earliest layers. The earlier layer it works, the better it would be. The shorter period of incarceration would be, the far less likely of incarceration of a juvenile in the adult jail would be. And that's what the solution is. And that's what we need to reflect.
Thank you for that. And I think the main takeaway for me there is how to crack those issue layers. What is the issue that's pervasive at each stage because of which it's failing? And I think we'll discuss that a little bit more in the question and answer session, but I also wanted to just mention yesterday you had said that the DCPCR managed to get a certain number of children out of jails in the last few months. So again,
that was because I conducted an inspection of the jail 5. And before I answer, another caveat. When you said only the jail 5 had 700 something, and while there are 12 or 15 odd jails, since we have been to one, you might know.
It's third or the second.
Yeah, because that's a young offenders
yes, exactly.
jail. No, but in the way I think it was presented, it made it look like as if the number is proportionately accordingly, which is not the case.
Yes.
So that's pretty much the only source actually. And it was just correcting for the how it landed. But to answer your question, that was when I had conducted inspection of jail 5 along with the Director General Prisons, and there were 21, if I correctly recall, juveniles. I mean, I'm not the one to indicate, suspected juveniles. And we got that process expedited. Of course, some of them turned out to be juveniles, some of them not. Most of them turned out to be juveniles, some of them not. So that was a process that we got expedited. So we got the DG prison to quickly escalate all of that to the magistrate.
Thank you for that. That actually raises a few questions in my mind, but before I move to my own questions, I'd like to open the floor for any questions that the audience might have.
Yes, sir. इसमें जो अभी एज के बारे में जो बात हो रही है, myself from CWC 7 member, तो मैडम ने कहा कि जरूरी नहीं है कि मैं हमेशा पुलिस में स्ट्रेट ही रहूं, कहीं और भी जा सकता हूं। इसमें मैं ऐसा क्यों नहीं हो सकता कि जैसे कैडर होता है, ये आईएएस कैडर ये राजस्थान के हैं या बिहार कैडर के हैं, केरला कैडर के हैं, तो उसी तरह से जैसे जो प्रिंसिपल मजिस्ट्रेट हैं उसी कैडर में रहे ताकि उनका प्रमोशन भी रहे, उसी के हिसाब से रहे। दूसरी बात ये आईओ के रिलेटेड में जो सर ने कहा कि इंक्वायरी ऑफिसर जो होते हैं वो जनरली उसको सीरियस नहीं लेते हैं, हालांकि उनको मालूम भी होता है, वो कहते हैं बच्चे को लेकर के यार तुम चले जाना।
मैंने ऐसा नहीं कहा।
नहीं सर, नहीं मैं आपको कहा कि वो लोन है सर। मेरा कहने का मतलब ये जो आईओ जो हमारे पास में आते हैं कहते हैं सर मैं इस आईओ का केस नहीं हूँ सर, ये मेरे पास आया है, वो अभी कहीं और है, ये मैं आपको दे रहा हूँ। अब उनको जो ये बताते हैं फिर ये कहते हैं कि आपको ये नहीं मालूम था, अगर आईओ है भी तो कह रहे हैं कि सर मैं नया आया हूँ, मुझको आइडिया नहीं है। तो होता क्या डिफरेंट केस में प्रैक्टिकली ये होता है कि डिफरेंट आईओज आते हैं, उनको मालूम नहीं होता है, तो वो इसको बहुत ही लीस्ट इंटरेस्ट में लेकर के लेते हैं। अगर इसमें भी अगर कैडर वो पुलिस वाले में जो आपने कहा जुवेनाइल एसजीपीयू स्पेशल जुवेनाइल प्रोटेक्शन यूनिट वगैरह में और आईओज वगैरह में कि अगर वंस यू आर आईओ उसी पे ही रहेंगे, वो बच्चों ही से रिलेटेड में काम करेंगे तो उनको सारे इंफॉर्मेशन आ जाएंगे। जैसे पॉक्सो के केस में फॉर्म बी इज द मैंडेटरी, लेकिन वो लाते नहीं है, कहने सर आपको तो मालूम ही नहीं था, ए उनको देना होता, बी आपको देना होता विद द सिग्नेचर ऑफ द एसएचओ। तो ये सारी चीजें हैं, यहाँ पर अगर ये हम जो सबने का इनिशियल लेवल पे हम कर सकते हैं तो शायद हम ही लोग हैं जो आईओ हैं और हम लोग मजिस्ट्रेट ऐसे जो पैनल में जेजेपी और सीडब्ल्यूसी में।
देखिए हम लोग नहीं कर सकते हैं क्योंकि जो प्रिंसिपल मैजिस्ट्रेट आता है वो एक ऑलरेडी कार्डर से आता है, वो कार्डर दिल्ली जुडिशियल सर्विसेज का है। तो जब दिल्ली जुडिशियल सर्विसेज में कोई ऑफिसर भर्ती होता है उससे इस तरह की कोई विलिंगनेस ली नहीं जाती है, ली जा भी नहीं सकती है। When a judge is appointed, be it at a district level or at a high court level or at a supreme court level, they can be allocated any work. So I don't think a special. Yes, I mean what can be done is that the ones who are more interested in any kind of work should be kind of brought in at such places. But then again, जज एज आई से द मोमेंट हम ये ऐसे कहते हैं कि जिस दिन हमने सरकारी नौकरी की थी हम तो नौकर थे, व्हाटएवर काम यू गिव अस विल डू इट। सो कोई स्पेशलाइजेशन हमारे यहाँ नहीं हो सकता है। जैसे मैंने अकेडमी में भी रही हूँ, मैं जेजेबी में भी रही हूँ, सेक्रेटरी डीएलसी में रही हूँ। एक किस्मत है कि मुझे इस तरह का वैरायटी ऑफ वर्क करने मिला, अदरवाइज वी एज जजेस डू ओनली जुडिशियल वर्क, राइट? So what you are asking is, it is not possible, it cannot happen. But yes, with constant training, and then again, it is a drawback of the system that even if you train those magistrates who are dealing with those cases of children sitting there in the juvenile justice board, you cannot expect that only they will have to face the situation, because as we are discussing, the problem usually occurs before the magistrates who are not dealing with the cases of children. A JJB magistrate probably will not fail in identifying the child. A magistrate would, because it's not his normal work. Right? So there is a problem. Even if you have a specialized cadre here, your problem will not be solved. Because the child will ultimately, will in such cases always be produced before another court, not before JJ.
सर 20% प्रॉब्लम है। बच्चे जो भी आते हैं सारे पुअर स्टेटस से आते हैं, तो उनके घर वालों को उनको बच्चों को काम कराने की वजह से ना, कि ये कहीं काम कर लेंगे तो वो उसका आधार कार्ड में एज बढ़वा लेते हैं। वो उस टाइम उनको पता नहीं होता कि बच्चे को कोई कभी किसी क्रिमिनल केस में इन्वॉल्व हो जाएगा। तो 20% केसेज ऐसे हैं जिसमें घर वालों ने, वो आईओ भी बार बार कहता है अभी कुछ लिया कर दो, कुछ लिया कर दो, वो कहता है जी हमारे पास तो आधार कार्ड है। तो ये मैंने नोट किया है कि कम से कम 20% तो सारे बच्चे ऐसे हैं जिन्होंने अपने आधार कार्ड में घर वालों ने उसकी एज जानबूझ के भी काम मिल जाएगा इसको, नहीं तो लेबर के चक्कर में उसको नौकरी पे नहीं रखता, कोई काम धंधा नहीं देता, वो आ जाते हैं। और दूसरा आईओ की फिर मजबूरी हो जाती है कि वो तो आधार कार्ड में ये है तो मैं क्या करूँ, और कुछ है नहीं उसके पास। अभी एक बच्चा 3.5 साल जेल काट के आया है, कल ही ट्रांसफर हुआ है मेरे पास। मैंने देखा कि 3.5 साल तो इसको वो भी जज साहब ने फिर उसकी एज डिटर्मिनेशन टेस्ट कराया, बोन कराया उसका, तब जाके वो 20 साल निकली। तो उस टाइम पर वो 18 का था, तो उन्होंने उसको डायरेक्ट डिक्लेयर कर दिया, तो अतः उसको छोड़ दिया। 3.5 साल तो ऑलरेडी वो जेसी में रह चुका है। तो ये प्रॉब्लम ज़्यादातर, मतलब 20% प्रॉब्लम ये है, आधार कार्ड बनवाते हैं जो उसमें एज वो अपनी ज़्यादा लिखवाते हैं।
जब आज साहब जेजेबी के मेंबर हैं और इसके पहले दिल्ली पुलिस में, तो इनका अनुभव मैटर करता है, क्योंकि सर ने दोनों साइड देखी। डॉक्यूमेंट्स को लेकर के अभी अनुराग भी कह रहे थे, डॉक्यूमेंट की कहानी थोड़ी सी इंटरेस्टिंग है और थोड़ी गंभीरता से समझने की जरूरत भी है। आधार एक्ट खुद कहता है कि आधार कैन नॉट बी जुवेनाइल जस्टिस लॉ एज के लिए 2-3 दस्तावेज ही वैलिड करता है, लेकिन वो एक डिटर्मिनेशन के लिए है, एक इन्वेस्टिगेशन के लिए नहीं है, राइट? तीसरी चीज, लॉ बदला है, आप देखिएगा बहुत बारीकी से बदला है। डॉक्यूमेंट्स कौन से लिए जाएंगे? द अर्लियर लॉ, द रूल 12 एंड जुवेनाइल जस्टिस एक्ट 2000 सेक्शन 49 और फिर रूल 12, दोनों को कंबाइन करके सेक्शन 94 बना दिया गया। 94 में आप देखिए जो हायरार्की थी, फर्स्ट अटेंडेड स्कूल, वो एबॉलिश कर दी और अब कह दिया स्कूल हाँ, फर्स्ट सर्टिफिकेट भी नहीं है, बर्थ सर्टिफिकेट ऑफ स्कूल, राइट? ये फर्स्ट अटेंडेड से मैट्रिकुलेशन और स्कूल, ये जर्नी क्यों हुई है, ये बहुत इंपॉर्टेंट है। पूरे देश में ऐसे लाखों की तादाद में मैटर आते थे जहां 8-8, 9-9 महीने सिर्फ फर्स्ट अटेंडेड डॉक्यूमेंट की खुदाई में लगते थे, और अदालतें एज का डिसीजन नहीं कर पाती थी, चाहते हुए भी, जानते हुए भी कि ये सामने खड़ा आदमी हमारा 10 साल का ही है, 12 साल का ही है, वो जो फर्स्ट अटेंडेड है वो लाना ही पड़ेगा। और पूरी मशीनरी दौड़ती रहती थी उस स्कूल की खुदाई करने के लिए, कागज मिला नहीं मिला, अब एक बार स्टेटमेंट आ जाएगा तो वो। और तीसरी चीज जो अफसर बता रहे हैं कि जो डाइवर्सिटी है, गरीब परिवारों के लोग बच्चों को घर पे छोड़ नहीं सकते, तो वो चाहते हैं कि जैसे ही वो नौकरी करने जाए उनका बच्चा स्कूल चला जाए। तो भले ही छोटा है लेकिन स्कूल में उसको इनरोल करा देना चाहते हैं ताकि घर पे वो अकेला बच्चा न पड़ा रहे। तो छोटे बच्चे भी हैं उनको भी 6 साल करके, ये सबको पता है और ये प्रैक्टिस है भी, वो गरीबी के संघर्ष है, वो चाहते हैं स्कूल में चले जाएं। जजेस ये जानते थे कि किस केस में एज को लेकर के क्या मैनिपुलेशन हुआ है, वो कागजों पे दिखता है। 40 साल पुराना रिकॉर्ड वो चमचम सफेद फाइल नहीं हो सकती। तो अगर आपने देखा कि पूरा स्कूल का रिकॉर्ड जो है वो चमकता हुआ आया है और ये 40 साल पुराना रिकॉर्ड है, वो देखने से ही लगता है कि ये अभी बना है 4 दिन पहले। लेकिन लोगों ने वो भी किए, पूरे स्कूल के रिकॉर्ड, केवल अपना ही नहीं 10,000 बच्चों का सबका नया रिकॉर्ड बनवा दिया, तो फांसी लगने वाली है, राइट। तो डिस्क्रिप्शन हटा दी, वो जो फर्स्ट अटेम्प्ट स्कूल का कंपल्शन है वो हटा दिया। अब वो सारा डिस्क्रिप्शन जजेस को दे दिया कि स्कूल है बस। अब वो पहला है, दूसरा है, तीसरा है, 10वीं तक अगर आप पास नहीं है तो 10वीं के नीचे कोई भी स्कूल का कागज नहीं है। अब वो जजेस का काम बढ़ गया है। अब उनको अगर 5 कागज हैं स्कूल के अलग अलग, तो उनको फाइंडिंग देनी पड़ेगी कि कौन से स्कूल का कागज। और वो एक समस्या का समाधान करने की कोशिश में एक बड़ी समस्या फिर से क्रिएट हो गई। अब वहां पर केस लॉ नहीं है ना। तो ये एज डॉक्यूमेंट वाला मसला एक बड़ी वजह है। और अब इसको आप चिंता कह लें या परेशानी कह लें, सुप्रीम कोर्ट भी आए दिन कुछ ना कुछ एज पे ऑर्डर करते रहते हैं, लेकिन उनका स्टैंडर्ड जो पोजीशन है कि कोई परमानेंट रूल एज डिटर्मिनेशन पर हम दे नहीं सकते, इट्स नॉट पॉसिबल। और जो भी लोग इंगेज करते हैं, लिटिगेट करते हैं, हम सब समझते हैं इस बात को, कोई फॉर्मूला हो नहीं सकता जो सारे केसेस में फिट बैठ जाए। लगेगा तो ऐसा लगेगा अन्याय हो गया, जो बालिग है उसको नाबालिग डिक्लेयर करना पड़ रहा है, तो वो दिल अलाउ नहीं करता है।
सर मुझे लगता है कि इसमें बॉटल ये भी है कि अभी तो जैसे आपने बोला एक डिटर्मिनेशन, ये तो बात का प्रोसेस है। जहाँ पे एप्रीहेंड की बात करते हैं तो वहाँ पे एक हमारा एक्सेप्टेंस, जो सिस्टम का एक्सेप्टेंस है, जो आयु से स्टार्ट हो जाता है कि कुछ ये भी लगता है कि बच्चा लग तो रहा है लेकिन इसने जो अपराध किया है, अगर हमने इसको जेजेबी सिस्टम में इंट्रोड्यूस कर दिया तो इसको तो कुछ होगा नहीं और दूसरी पार्टी सेटिस्फाई नहीं होती है। तो फॉर अ टाइम बीइंग कभी-कभी ये पर्पसफुली भी किया जाता है, क्योंकि डिटर्मिनेशन इज अ लेटर प्रोसेस। पहले बच्चे जब एप्रीहेंशन पे ही लग रहा है कि वो बच्चा है तो वो आ जाना चाहिए जेजे सिस्टम में, लेकिन वो एक एक्सेप्टेंस जो है सिस्टम का कि जेजेबी में तो बच्चों के साथ कुछ ऐसा मतलब आपराधिक वो तो है नहीं ना ट्रीटमेंट, तो इसको पता चलना चाहिए इसने क्या किया है, वो भी एक माइंडसेट है सर।
Especially in the cases of POXO, we work in jail number 5 Avnish के साथ। POXO के cases में the other party really wants pressure कि आयु के ऊपर कि please keep this person above 18. So that pressure you should also consider that आयु के ऊपर हमेशा रहता है।
After you have changed this law of 16 or 18 का category बनाया, तो कहीं वो उसको justified उन्हें लगता है जो वो कर रहे हैं वो ठीक है।
तो मतलब हम लॉ में और अपने पर्सनल थॉट में डिफरेंस नहीं कर पाते हैं कि भाई जो लॉ है भी है, हम पर्सनल कैपेसिटी में शायद ना माने लेकिन लॉ है तो वी आर बाउंड टू फॉलो इट, वो मुझे लगता है करना चाहिए।
2-3 चीजें एक, and I'm going to sound slightly harsh, it is well within the right of the other party to even want to go to the moon, not just 18 के ऊपर। तो अगर हम चांद पे जाना चाहते हैं भी आपका अधिकार है चाहत रखना, एक लोकतंत्र आपको अधिकार देता है, आप रखिए चाहत, आपको प्लूटो पे जाके रहना वो भी चाहत रख लीजिए, लेकिन क्योंकि आप एक पार्टी चाहत रखती है, the holder of public office discharging my constitutional and legal responsibility, have no business with your chahat. So while I appreciate your right to have whatever chahat you want, I don't need to give in to it. And while I acknowledge that such pressures exist, but not caving into such pressure is the precise job of the one holding a constitutional, statutory, legal position. क्या जजेस पे प्रेशर्स नहीं होता है कि ये व्यक्ति ऐसा है, ये व्यक्ति ऐसा है? is their job to resist that pressure. So that's one. The second, and केसर में आपका बड़ा important point है, and I realize this to an extent in my own heart. कभी ना एक मिनट CCL को भूल जाइए. कभी सरकारी स्कूल में सबने विजिट किया होगा या बच्चों से बातचीत की होगी. जब पूछते बेटा क्या बनना है, तो कोई बच्चा अगर खड़ा होकर some one student stands up and says, I want to be an astronaut. Let's have it. Hand on the heart. We don't fully, we say all the nice words, yes, beta, you will become, work hard, etc. But hand on the heart, we don't really believe that this child will. Or this child can. Because there's a cultural prejudice at play. There's a cultural bias at play. That we don't believe our children. And whether the child becomes astronaut or not, that's separate. But we just don't believe in the capability, in the capacity, in the potential of this child to become astronaut. Similarly, when a child is presented before the board, we don't believe in the presumption of innocence. We genuinely don't believe in it. And when we don't believe in it, is the set of the questions that come, क्या होगा, इसको ठीक करना है, ये सीखे, और सिस्टम में जाएगा, सड़ेगा, सीखेगा तो ठीक होके निकलेगा. And all these kind of questions come into the picture. And that extraneously affect the questions of bail, even eventual order sometimes as well. So that's a cultural problem. That's less of a judicial problem. And how do we solve for it culturally? And not just for children, also for children. Even very quickly, someone's arrested and a fine is lodged. Oh, kiya hoga corruption. Oh, kiya hoga ye. This is like a cultural bias, and which is why it is no surprise that when the 4 men accused of rape, I think Hyderabad or somewhere, are encountered, people are not out in the streets asking about how the hell could you encounter. Whether they committed that horrific crime or not is for the court of law to decide. And if they did, there's a justice process by which they must serve their sentence. Even if they did, and we don't know whether they did, but even if they did, encountering them is not sanctioned by the law. But somehow, our country cheered that such people must be met with such faith. And it reflects a cultural belief that we need to reflect on. And I spoke to a few people in that moment, I think it was 2 or 3 years ago. And I spoke to a few people who were cheering, and some of whom happened to be people known to me in my friend circle, in my professional circle, who I know to be good people. So it's not even that I can say that they're boycotted, petty, mind, and dismiss them on that ground. And I spoke to them, and I can understand the frustration with which they come. That means कुछ नहीं होगा. So that the point Anand was earlier making कि उन्होंने system में भरोसा खो दिया है, तो उनको ये gap नजर नहीं आ रहा. And unless the system starts to work, be function and deliver, that frustration will only grow, and the bias and prejudice will only grow.
The very fair point that it's very often a frustration with the system that makes all the various stakeholders want to find a solution around it. The protections given to children leave certain stakeholders feeling somewhat frustrated for various reasons, and so there's a desire to subvert the protections in the system. But I'm very cognizant of time, and so the thought that I want to leave us with as we finish the session is, अब हम क्या कर सकते हैं? आगे बढ़ के क्या किया जाना चाहिए? So मैं हर जगह से पूछना चाहूँगी, बस 1 मिनट के अगर आप एक सोच हमें दें कि क्या होना चाहिए, low hanging fruit. I'm not talking about a larger systemic change of making everybody change their perceptions. I'm talking about implementable ground level action that we in the room, as lawyers, as members of the state judiciary, as members of the CWCs, as NGOs, as researchers, do you have any suggestion for us on what we can do to even implement a small level of change to try and bring about a system that we're all happier with seeing? And of course, before that, if Gitanjali would like to respond to Anuradha's ma'am's comments about the data, we'd be happy to hear that first. And then I'll just ask us to go down the row. अभी चलने में पहले बता सकते हैं. हर जगह मुझे प्लीज ये बता दें कि आपके हिसाब से क्या किया जा सकता है that can cause some level of change. This suggestion for us as we leave the session. Thank you.
Diksha. I'll start with the data. We're actually filing applications, clarifications for both those things. It made no sense to us. One sort of hypothesis we had was that it's possible that the superintendents of the jails are providing data on those they have identified in response to that question. But we are filing clarifications in both those cases. I think I really connected with this idea of cultural beliefs, and that's sort of what I'm going to use to lead into a possible sort of recommendation. Or I think it's a very dangerous idea, this idea of normative hierarchies and cultures that we perpetuate. We see this constantly, and in the same study in Uttar Pradesh, there was a case where a chief medical officer of a district had pronounced that a boy who had already spent 4 years in jail, was 19 years old at the time of the bone ossification test. That report was sent to the sessions judge, and he called for witnesses at the next date. He did not transfer the child's case to the JJB. It was only after repeated interventions that he did so. The lawyer said that he didn't have the voice to ask for the transfer. He said that he was terrified and of speaking before the judge. And so, ma'am, to your point of a principal magistrate flagging this issue, I think there's no option but to say this is Section 8, M of the JJ Act, and the principal magistrate has the powers to flag it, and they must. So I think sort of taking from that, Rule 329 of the Delhi prison rules actually say that there's one more flagging point, which is when the medical examination happens for new entries into the jail, the medical officer can write to the court and say, I think that this child is a juvenile. So perhaps one way to start is just track prison rules across the country, see if this is a provision, and try to operationalize this either through civil society that enters prisons and through other ways. Yeah, thanks.
Thank you. Anand?
Okay. 6 months ago, this Vinod Katara case was decided by Supreme Court. उसमें उन्होंने एक आपको एक कोड लिखा है, उसमें उन्होंने लिखा है कि age is a क्या है? State of mind. Yes. Age is a state of mind. Age is an issue of mind. Over matter. If you don't mind, it doesn't matter. But in criminal law, age matters. Right? And law, we have discussed how law is working. How do we correct it? So I'm trying to give my one bit of what I think now should be done. That you hit the state where it hurts hardest. And where what hurts the hardest is, for all of us, money. Right? So while we continue law reforms, conversation, dialogue, use law to make state pay compensation, ask for compensation, and I can guarantee as you will start extracting more and more compensation from the state for these violations, you will see these violations will come down and the accountability will increase. Thank you.
Thank you. Abhi, sorry, I was last Abhi was going to come back to the second. Abhi,
तो जब जेल में जब बच्चे जाते हैं तो उनको खुद को नहीं पता होता है कि हमें इस जेल में क्यों डाला जा रहा है। तो जो ड्यूटी का गेट होता है, अगर वहाँ पे कुछ पोस्टर्स वगैरह अगर लग जाए, जैसे कि आप अगर 18 इयर्स के अगर आप नीचे हैं तो आपको इस जेल में नहीं रखा जाएगा। कुछ चीज़ें अगर रिस्पॉन्सिबिलिटी अगर जेल स्टाफ ले कि जैसे कि उनको पहले ही दिन पता चल जाता है, जो एक PMS ऑफिस होता है जहाँ पे पूरी उसकी डॉक्यूमेंटेशन होती है और उसको बायोडेटा उससे पूछा जाता है, केस से रिलेटेड सारी चीज़ें पूछी जाती हैं, तो स्टाफ को पहले ही पता चल जाता है कि ये माइनर है या नहीं है। अब ये तो कुछ तो बताएगा ना, पुलिस को कुछ भी बोला उसने, लेकिन उसको तो कुछ ना कुछ बताएगा कि एमपी 18 है या 21 है, जो भी है, तो वो एक्शन ले सकती है। तो मेरे ख्याल से तो अगर जेल प्रशासन या सुप्रिंटेंडेंट अगर एक्शन ले तो ये हो सकता है कि वहाँ से जो प्रोसेस है वो जेजीबी जो कोर्ट्स हैं अगर वहाँ तक वो पहुँचे तो वो प्रोसेस जल्दी से जल्दी हो पाए। अगर तिहाड़ जेल वो चले भी जाते हैं तो कम से कम वहाँ का जो प्रोसेस है वो 1 से 2 महीने, जैसे मैंने कहानी बताई थी कि 3-3 साल 2-2 साल, बहुत सारी कहानियां मेरे 5 साल के स्ट्रगल में बहुत सी ऐसी कहानियां देखी जो लोग एक बार तो ये हुआ कि उसको किसी ने बोला कि आप तो 2-3 साल तुम यहीं रहो, कुछ नहीं होगा तुम्हारा, तो उसने गलती से आपस में लड़ाई कर ली और ब्लेड कुछ मार दिया किसी के, और उस पर एक और केस लग गया और वो उसको कस्तूरी पैक कर दिया और वो इतना मतलब फूका टाइप का कुछ हो गया कि अब तो मुझे रहना ही है, तो मैं अब क्या करूंगा, जबकि वो कह रहा कि मैं छोटा हूँ और मुझे यहाँ नहीं रहना चाहिए। और पता नहीं उसे जब चला जब वहाँ का जो पीयर जो सपोर्ट होता है उन्होंने बताया तब उसे पता चला, लेकिन उसको भी करीब 1 साल कुछ महीने लग गए कसूरी में रहते रहते। फिर उसके बाद जब उसको जेजीबी ट्रांसफर हुआ तब वो 2 महीने में करीब वहाँ से छूटा। तो थैंक यू।
Since I am in High Court Legal Services Committee as of now, and more because Anand is also here and is working with TSLC, what I feel is a better network of lawyers from the stage of police station up till the state, up till High Court, or maybe up till the Supreme Court will work. So when a child is apprehended, there itself, if there is a person to tell him or to check the issue, and then that person is in touch with the lawyer as a JJB provided by the DSLSA or by the NGOs or few people, you have a connectivity and a proper network. The moment the child is there, this person communicates to the court of concerned magistrate, because the child will either be produced before a JJB or before a magistrate. So one, he can raise the issue there itself with the IU. If the IU doesn't listen, then he communicates to the lawyer at the JJB and the lawyer of the concerned police station, concerned magistrate of that police station simultaneously. And then if they fail there, then to the lawyer who is posted in the sessions court, who can then again check it. So at multiple layers, not only the lawyers are provided, but they are in touch with each other. They are constantly talking to each other. This might help.
Thank you, Ratna. And we will end with Mr. Kundu, who's spoken at length about all the different failures. So where do you think there can be some level of incremental change?
Sure. Let me first go back to the point Hitanshi was making, and it will sound like a joke, but I'm very serious about this one, and which is the vakil who is terrified in raising a point of law to the judge should quit and should quit practicing law forever. मतलब एक काम है वकील का कानून खड़े होकर जज साहब के सामने आर्ग्यू करना, और कोई काम ही नहीं है वकील का, क्या काम होता है वकील को उसके अलावा, तो वही काम में वो टेरिफाइड है, तो फिर घर जाए, और मैं तो कह रहा हूँ घर ना जाए, क्योंकि मनी की बात चाहिए तो मैं आगे बढ़ूँ, अपने कॉलेज से रिफंड मांग ली, you have not prepared me in my LLB degree, so give me the compensation, give me my feedback, and the vice chancellor should look at him and say, हाँ भैया तुम तो deserve ही करते हो, पहले तुम 2 extra ले लो, we have ruined you basically, but okay, इसलिए वकील काम क्या है? वकील का काम एक है सर, that's it.
वकील में ना सेंसिटाइज वकील अगर आप सेलेक्ट करेंगे ना तो वो वर्क करेगा। आप अगर ऐसे वीडियो कटिंग करेंगे उससे फिर काम नहीं होगा। सेंसिटाइज वकील को आपको अगर रोल प्ले करने के लिए देंगे,
किसी और का वकील हुआ किसी और मैटर में,
नहीं देखिए आप जो वकील के लिए बोल रहे हैं ना वो सारे वकील एक से नहीं होते हैं।
बिल्कुल नहीं।
आपको जिस तरह से चाइल्ड फ्रेंडली आप अगर बनाएंगे वकील को, वो आपकी पैरवी करेंगे तो इफेक्टिवली पैरवी होगी, अदरवाइज नहीं होगी। इसी तरह से जो मैजिस्ट्रेट हैं या
पुलिस ऑफिसर्स जो आपके थाना है उस लेवल पे अगर कोई आप मतलब सेंसिटाइज नहीं करेंगे तो कैसे काम होगा?
Completely agree. So that was the earlier point that I made of the whole chain. And of course, सारे वकील एक जैसे नहीं होते. Here is a also वकील who has guided me, mentored me through so many other things. I can see a lot of other वकील in the audience who I have great respect for.
वकील होना
Madam
भी
also has some IITs, and I don't know whether Diksha has or has not. But there's so many वकील. I'm referring to one specific वकील who is terrified in raising a point of law to the judge and thus doing injustice to the very court whose officer he is, to the very constitution he is supposed to protect, promote and represent, and to his client who is in such grave situation. I'm referring to that specific wakil. And of course, there are amazing wakil, as is the case in all the professions. They're amazing in all sectors, they're not so amazing in all sectors, and they're absolutely bad in all sectors. But to your point, Diksha, so I will not say what others can do, let me say what we will do. And I think two quick points. One is better tracking and monitoring of the compliance with respect to triple time judgment, which provides for a lot of answers. That's one. And that might require capacity building, campaigning, awareness, monitoring, data management systems, so on and so forth. And lastly, preparing our adolescents better on understanding of their legal assertions. So I think those are the two components that where we have both the capacity and the responsibility to intervene.
Thank you for that. I look forward to many of these suggestions being implemented, both by the CPCR and very many of us in the room who can take these practices forward. So that's the thought I would like to leave us with today, that this is a very, very pervasive problem, one that has gone on for such a long time, but there are suggestions. There are things that we can all do at a personal, incremental level to try and bring about systemic change. So with that, I would like to wrap up this panel. Thank you to all the speakers.